Hello, everyone. Thank you for joining us for today's webinar. It's 12:01, so I just want to give us a couple more minutes so we can have more people that are trying to log on maybe be able to do that. So we'll start at exactly 12:02 thereabouts. So just a few more seconds and we'll get started. So thanks, and I will be back shortly. So, hello everyone. I'm back, and my name is Angela Princewell, and today I want to talk to us about collaborative family law, which I believe is a better way to divorce and separate. I have a whole lot of information that I would like to share with you, so I will go through them. I'll just be throwing a lot of information at you very quickly. So, if you have any questions, somewhere on your screen, maybe at the bottom or on the right-hand corner, somewhere there will be the options for Q&A or chat. If you could put your questions in there, I will try to get to it as quickly as possible. Well, towards the end, as when we're able to. I would also and I find that sometimes I'm not able to get to questions right away, and we would usually have answers posted either in a follow-up blog or sometimes that even forms a topic for another webinar. So, but we will try our best to get through questions today. So let me just jump right in. Okay, give me 1 second here. All right, so your relationship is over and you have to, it's time to move on. And as your lawyers, we recognize there's a lot of feelings you're going through right now. You're hurt, you're angry, and in some cases you're just resigned to the fact that the relationship is over and you just want to move on. And you're wondering, what way do I go about resolving all of the issues that have arisen? Usually when I hear people, when I hear divorce or separation, there's big topics that come to mind, right? If there's children involved, how are they going to be taken care of? How would your finances look like? What about property that you've acquired during the relationship? How does that get taken care of? So there's many ways that you could go about resolving these issues, and we want to make sure that you do it in the best way for your family. So I say that recognizing that collaborative family law it's a better way, but it's not for everyone. And we know people, you've talked to your friend, in some cases you even get independent legal advice from a lawyer, and you could represent yourself. There's just so many ways that you could go about resolving these issues that arise out of family law. And with all of this, I know a lot of people don't get don't get information about collaborative family law, and that's what I hope that I can share with you. But before I even go into collaborative law, let's talk a little bit about some of these other areas of resolving family law disputes. And I've actually highlighted the 6 areas that I would want to touch on. So one is negotiation between the parties directly, usually resulting in something that we would call a kitchen table agreement, or in some cases, actually having lawyers draft the final paperwork. So there's mediation, there's the collaborative process, there's lawyer negotiations, arbitration, and ultimately there's the courts, who are usually the only ones that can actually compel anyone to do anything. So negotiating between the parties generally involves you and your soon-to-be ex talking things out and maybe drafting a separation agreement yourselves, or in some cases you come up with the terms, you get independent legal advice from a lawyer, and you retain a lawyer to draft the agreement for you. It's a great option, and it's definitely the cheapest option in resolving your family law disputes if you're able to communicate amicably with the other side. It's important to look out for, I would say, power. I would call it power imbalance. So if you're dealing with someone that's very manipulative and things like that, then probably negotiating with that person may not be in your best interest. So if that person is someone that maybe triggers, knows your triggers and just sort of takes advantage of that, then maybe it's not a good idea to negotiate directly with the party yourself, because you may be getting a deal that's not good for you. And by good for you, I'm not just talking in terms of dollars and cents. The focus of this webinar is really to get to your interest, not just what the law says you can get, which is really what the collaborative process is all about. So anyway, you guys can negotiate on your own and you come up with your agreement. I would say whatever you do, make sure you get a lawyer to draft that separation agreement for you at the end. That's imperative, because the amount of times where people draft agreements themselves and years later it ends up in litigation just for something as simple as lack of clarity, it's crazy. So whatever you've agreed to, you want to make sure that it's documented exactly as discussed. You want to make sure you have another lawyer look it over. It's relatively inexpensive, and it's just such a small fraction of the cost that you would have to incur if in the future there's ever an argument over what something means. You would be surprised how often that happens. So negotiating with the other party, honestly, it's fantastic where appropriate, and I always encourage it. It's the cheapest way, it preserves your relationship, and especially where there's children involved, it's great to know that if you can negotiate final settlement terms, then maybe it's more likely that you'll be able to negotiate co-parenting terms, things like that going forward. The other option is mediation. Mediation is where you get a third party to assist you in the negotiation process. So this is great where you're dealing with a power imbalance. So you have sort of that third party making sure that one party isn't necessarily being taken advantage of. Again, here, using those words, in very loose terms, because it's not about getting to a particular result. It's just about getting to an informed decision, right? So if, if you want to keep things amicable and inexpensive and, preserve goodwill, and but you don't feel like you can have a conversation that would be amicable with the other party, then involving that third party, that mediator, can really move things along. And most mediators are just really there to facilitate that conversation. They don't make a decision for you. They don't push either party in any direction. They would often advise, if it's a lawyer mediator, they may give you an input on what the law is in your situation, but always you will be required to go get independent legal advice. And and then generally when you're done, you enter into a memorandum of understanding. And I want to point out that most people forget that with the memorandum of understanding, that it's important that they get the separation agreement drafted by a lawyer, because usually it's unfortunate in some cases people actually don't do that. They think with just having that memorandum of understanding, and if everyone's just kind of following the terms, that's enough. But sometimes it can lead to challenges because it's really not a separation agreement. And if things need to be enforced, then that could be a problem. So the collaborative process is the next step. And I kind of listed those six, ways that you can resolve your disputes in order of how expensive they are and time consuming. So collaborative process is somewhere in the middle. I guess would rank it right after negotiations between parties directly and mediation. But I'm going to save collaborative process for last, for the obvious reason that that's what we're here to talk about today. So lawyer negotiation, this is a great option. The only problem with lawyer negotiations, and this is by lawyer negotiations, I mean, each side has a lawyer that they're working with in help that's negotiating these settlement terms for them. So with lawyer negotiations, the only challenge I often see is that it could very easily escalate into litigation. There's a lot of posturing by the lawyers, and if both lawyers are not settlement focused, then it could just really be a pointless exercise, and you could spend a lot of time and resources to find yourself end up in courts, which more often than not is where most people don't want to go. So it's important where it's lawyer negotiations for both lawyers to be settlement focused. And if they are, then it could be very cost effective, right? What's the point? And both lawyers, if they're experienced, kind of have an idea of the range of results they would get for their clients if the matter went to court. So having that idea in mind, and also being able to advise clients of, along those lines, it's very easy to negotiate an agreement that both parties can live with without having to escalate things any further. So just to be, it's an option. It's honestly usually a preferred way that I like to start my matters. And if it doesn't escalate, then it's usually leads to a separation agreement being done. And, hopefully everybody respects what they've agreed to. And that's that. Again, it's pretty cost effective if both sides are focused on settlement. There's arbitration as well, where, you have a judge, well, I'm going to call them a judge, but they're the arbitrator, make a final decision. And it's almost like having a judge, except that you get to pick who your judge is. It's usually faster. Arbitration is expensive, in my opinion, because you have to pay the arbitrator, and you're usually having to pay your lawyers as well, if there's lawyers involved in arbitration. But the advantage is just, it's still, despite the cost of arbitration, it's still way cheaper than going to court, because a lot of the procedural steps that are involved with courts, you don't have to do those in arbitration. And then you get the option of picking your arbitrator, right? So if you have lawyers, usually we would negotiate who we want to act as arbitrator on the matter, and we don't get that option with a judge. And with court as well, you have to go through the various steps that are involved with arbitration. You could just get to it very quickly. A lot of times for our matters, we would suggest mediation arbitration just to keep things streamlined. We'll try to negotiate a settlement. If it fails, then obviously it moves to an arbitration and just have someone make the decisions very quickly. You generally don't get to do that with court. So the last, step that I want to talk about is obviously court, which is a lot of people's default. They think that once they have this family dispute, they have to, it's either they're negotiating themselves or they have to go to court directly. And you can see that there's a lot of ways to go about this without involving the courts. But the courts serve a very, very useful purpose, despite the fact that court can be slow. It can be expensive, and the fact that you lose the opportunity to enter into, more creative, customized settlements, because now you're putting everything completely in the hands of a third party. And sometimes, a lot of times, the judge that's deciding a matter of trial is not even the judge. It's definitely not the judge that has been assisting the parties in a settlement. Those are distinct, very clear disadvantages. but it has its own purpose, right? Some people will just not budge. Some parties would just not cooperate with any other process, or they just drag things on. If disclosure would never be produced, if someone's not going to respond to inquiries, if they're going to consistently breach agreements that have been reached, then you have to go to court. Then it's a necessary enforcement tool that's there. It serves a purpose. I like to think about it as sort of the last resort, but it's there for a reason. It can help you move your matter along, and it can help you make sure that you have a tool to make sure you enforce agreements and things like that. And even with the delays, if someone's just not responding to you anyway, the courts at least have timelines in terms of moving matters forward. And as slow as it may be, the day eventually comes, and if the other side is still is not cooperating or participating in the process, then you could just proceed in getting the order that you want, and just at least bring some finality to the process. So now, collaborative process. So collaborative process to resolving your family law dispute is a dignified way of doing things. It's a process of dealing with all the issues that have arisen as a result of your separation, but without having to do it in a cutthroat way. It's a way of respecting the other side, and acknowledging that yes, the relationship is over. My family is going to be transformed. Life is going to be different, but it doesn't have to be. We don't have to get through this change aggressively, or in a way that just completely destroys the family unit. So if you're dealing with, there's some cases where you absolutely can never ever. The person has to be in your life, right? I know there's times when people go through a separation, and they would rather they never saw the other party ever again. But there's times when that's just not possible. If it's a long-term marriage and your families are intertwined and things like that, maybe just never, you might not have that option of never being able to see the person ever again. There's times where there's kids involved, for example, or just sometimes there's just not that much animosity. And even where there's animosity, I still promote using the collaborative process, because whatever challenges you have with the other person, or whatever it is about them that's upsetting you, having a fight in the courts or through lawyers is so unproductive, and it's extremely expensive. So with the collaborative process, both sides have lawyers. So I'm going to explain what is the collaborative process really. It's a process that parties get to resolve their issues based on their interests, what they really truly want, and not just their respective positions. And I would explain in a minute how interests and positions are different. For it to be a collaborative family law process, you have to have two lawyers involved. So party A and party B each have lawyers, and both lawyers and the parties have to sign a participation agreement where they state that if the matter doesn't settle, the lawyers cannot represent those parties if it moves on to litigation. So it can move on to litigation. The parties can decide they don't want to continue with collaborative family law, but in those cases, they would have to go get new lawyers. Having said that, most collaborative family law matters settle. I believe the stats has it somewhere at about 90% of collaborative family law cases settling. So when you have two lawyers and the posturing, take away the threats of going to court, it's amazing when we really get down to what matters. It's amazing how much or how things matters really settle, right? And that's really what I think most clients want. You want results. You might be angry. You might be going through a whole lot of emotions, anger, and all of that, blame. But at the end of it all, you want results. And collaborative family law allows you to have that, and takes away that aggression, and takes away the unnecessary expense, and just that constant threat at the back of your mind of knowing that this might be going to court. Because generally, signing that participation agreement is a sign of commitment to the process. So if the parties do not, if the lawyers and the parties haven't signed a participation agreement, it's not collaborative family law. The lawyers might be trained collaboratively or they might be settlement focused, but for it to be an actual collaborative process, it's important that that participation agreement rather should be signed. So with the respective lawyers representing their clients' interests, they're able to sit together and say, what do our clients really want out of a process? So I'm going to illustrate what I mean when I say interest versus position is, while under the law, a party might know, okay, I have a right to child support and I have a right to spousal support. And it's very easy to just run the numbers and know exactly what, the numbers are. And if you're not in a collaborative process, you could get so caught up arguing over, what the spousal support amount should be and how child support would be paid. Lawyers could get caught up in all that, but sometimes when you really sit with the client and ask, what do you really want? Um, one party maybe doesn't really care so much about spousal support, but wants a chance to keep the home. And so if you don't get to the interest, you're having an argument or you're having disagreement about something that looks like it's about support. But really the only reason why party A is so insistent on getting support is because they want to keep the matrimonial home. And the reason why they want to keep the matrimonial home is because they want to make sure that the children are okay and that the children don't have to go through so many changes. And then you find out that party B is also trying to not pay that much in spousal support because they want to make sure that they can afford to take care of the children. So when we really get to sit down and really look at the interests, you see that both parties have the same interests. And in a collaborative setting, we're now able to brainstorm, not just one lawyer coming up with something and thinking theirs is the best idea and another lawyer doing the same, and then just presenting both options to a judge or an arbitrator to make the choice one way or the other. In a collaborative process, you might, with having both, all the parties brainstorming, or at least the lawyers, you can come up with ideas that are way better than each individual lawyer could have come up on their own. So that's what I mean by, and I could just point to so many examples where if we take away positions and if we get down to what the parties really want, you find that things don't have to just be, the parties are actually after the same things. They're not just on opposite sides. You might be able to get that support amount that you want for the reason that you want it. And the other party that has to pay that amount, maybe understanding where you're coming from, may not feel so resentful having to pay it, or might find a way around it, and everybody comes up feeling just a little bit better, or maybe just with a little less animosity than they ordinarily would have otherwise. So the base of a collaborative family law process, the very basics, is just that participation agreement between two lawyers. But the beauty of collaborative family law is that we also can work as a team. So a collaborative family process can involve a family or financial specialist and a family coach. So, and these are people with, the financial specialist, as the name, already gave away, is someone that specializes in dealing with finances. If you've ever been involved in a family law matter, you would understand that financial disclosure is the bane of everyone's existence. And it's the most important part of the process, because we can't calculate support obligations without having, the parties' true financial picture. We can't do equalization if we don't know what the other party has. The amount of times that people, the lack of trust with, is the disclosure full and complete? Is there something being hidden? Why is it taking so long? And sometimes it's just taking so long because one party just doesn't have the time or desire to sit and put together their financial disclosure to give to the other side. So in the collaborative process, you can involve a financial neutral. They're usually cheaper than lawyers, and they're better skilled, they're specialists at dealing with numbers. And the beauty of it is they gather the materials for both sides. They're neutral, they're not representing one person or the other. And the beauty of it is with the financial neutrals, you can have, one party just drop all of their receipts with a financial neutral, and the person can go through the receipts and figure things out. These financial specialists can help with coming up with the budget, right? Because sometimes even just the numbers don't tell enough of the story. So we might, again, back to my support example and negotiating based on your interests, we might be arguing over $2,000 in spousal support. But maybe, and with spousal support, there's usually a range. So we might be looking at a range of, say, $2,000 to maybe $5,000 in someone's, and we just get caught up in those numbers and just we're trying to win the best we can for our clients, which it's the job of the lawyers to do. But when you have a financial neutral, maybe prepare a budget, then you might find that, okay, maybe the other party might understand better where these needs are coming from, right? And that's something that the financial neutrals are able to do really well. And they can create a budget, not just for one side and each lawyer doing theirs, they can create a budget for both and can actually help both parties understand how to live post-divorce, because, it's cheaper for two people to live than just, people living separately. And it's a shock for most people. Finances would not be the same, and lifestyle might be affected, and it's nice to have that neutral third party assist in that process. And I find generally it also helps the party that's paying support or having to give an equalization payment. It makes them a little bit more vested in the process because they feel a lot more connected in that way. And it's cheaper. Did I say that already? So it is cheaper to involve the financial neutrals. And they're also skilled at being able to, follow the money. So as opposed to one lawyer just getting, paperwork, and then we're writing to the other, trying to uncover accounts that have not been disclosed and things like that. It's easier when it comes from these financial neutrals. They're able to follow the money and say, okay, this is, I see there's XYZ going into this other account. Can I please have that disclosure? And somehow it's perceived differently than it coming from a lawyer. Or maybe they're just able to uncover things in a way that, the lawyers just can't. So I find that involving the financial neutrals, it's so helpful. Things move along much quicker than when it's just, a lawyer trying to pull teeth and getting the other side to disclose. And the results are just generally appreciated better by the parties. There's also the family, we can, as part of the team, so you have both lawyers, and now we've talked about the financial neutral. There's also the family, we call them the family professionals. And I mean, they're usually therapists or social workers, and their job is to deal with the emotional aspects of the separation. And every separation has an emotional aspect. I don't care how long it's been. It doesn't matter how, what the parties say, there's always that emotional aspect to it. And it may not just be in the form of anger or anything. Sometimes it's just a mental block to be able to reach a settlement with the other party. Having a family professional as part of the collaborative team just really helps, helps the clients and, see their own blind sides, and it helps them better understand things. But the greatest appreciation for me comes with files that include children, because at the heart of all of this, more often than not, both sides fighting over different parenting schedules are really just trying to get to what's in the best interest of the children, right? So in a normal, let's say in a litigation process, the applicant has, their own side of their own side of things, and the respondent has their take on what's in the best interest of the children. And, it's just not, and it just doesn't it's just a lot of fighting. They just don't see eye to eye on how one person's plan is better. And I think sometimes people just get entrenched in their positions. It doesn't make anyone a bad person, but when you create a plan on your own, you're sort of vested in that plan, and you just kind of go all out trying to defend that plan and it being in the best interest of the children. But having that social worker or that therapist, counselor, be able to talk to the children, talking to both parents, and helping the family come up with a plan, not imposing their own plan, but helping both parties see what really is in the best interest of the children here, and helping to stop that mental block that might be existing in the situation and just that might be preventing a settlement. It's so priceless. And again, these family professionals are usually less expensive than lawyers. So you find that working in this sort of team environment ends up being very cost effective. So having that parenting professional that sits with both parents, either together or individually, and tries to, create a plan for them that gets to the root of what both parties want, which is the best interest of the child. And the neutral is able to talk to both. So if I'm acting on the litigation file, for example, I would never ever hear from the other side directly. More often than not, they have a lawyer. I hear, party A tells their lawyer something, party B tells their lawyer the other thing, and then we try to negotiate a settlement. It can be very inefficient, but we make it work. I mean, we settle a lot of files, so we do make it work. But when you have sort of that team effort, I think it's very well suited to those very difficult files where both parties honestly and genuinely want what's best for the children, but and this is just a better way to get to that. There's less animosity because the family professional would make sure that communications are respectful, right? There is really no purpose served in being disrespectful to someone. Again, if you want to have a fight, I tell people you don't do it with the professionals. It just costs you too much. You did not come. If you retain me as your lawyer, you're not retaining me to fight with the other party. You're retaining me because there's specific results that you want. If you want children, you usually would want a parenting plan that's in the best interest of the children. If there's property involved, you want to make sure that the property settlement is fair and it's what you're entitled to under the law. Or if there's specific assets that you want, you're retaining me because you want to make sure that you keep those specific assets. If there's support, you want to make sure that that support is fair and reasonable. That's what you want. So all of the fight and the disrespect and things like that are just not necessary. And the beauty of the collaborative process is that you can really rest easy in going through your separation, knowing that you don't have to deal with all of that. So often clients would get, a forwarded message from another lawyer or something, and it causes so much anxiety, right? Or even hearing from me, it's like, okay, there must be some communication from the other lawyer, or maybe this means that my court's coming up. And it's amazing to me how much anxiety that causes clients. And the beauty about the collaborative process is I can say rest easy knowing that you're not going to get, just an overly aggressive letter from the other lawyer. Yes, we will disagree. Yes, I will have your back. Yes, I would make sure that, your interest, again, not just your position. It's not just random numbers. I want to make sure that the numbers work for you. I want to make sure that the settlement you're getting can align with your goals. So we would get to all that, but we're going to do it in a way that you can sleep easy at night, and you can, you don't have to be terrified every time that you hear from a lawyer or that the other party shows up and things like that. We just really try to take all of that out. So the team, again, I'll just go over the collaborative team. It's the lawyers, a financial specialist, and a family professional. So you see that the legal, the financial, and the emotional can get taken care of. But you don't always have to have a team. In some cases, it's not necessary. So long as you have two lawyers who have signed an agreement and have agreed to participate in a process where if a settlement is not reached, they cannot represent the parties in litigation. You have your collaborative process right there. Um, so as you can see, I mean, working with the team is helpful. And I know someone had asked me a while ago that, you know, if I don't have children, what's the benefit really to working with, you know, a family professional? And I think there is still benefit there because sometimes there's a mental block, and I can't express it as well as a family professional would clearly, but we all have these mental blocks and we all have these triggers. And when you're trying to reach a settlement, besides just even when one party might recognize the sense in what you're doing and can acknowledge that it's the right settlement approach, logically they can, but for some reason emotionally they're not able to move on, and they need the help of that family professional to kind of guide them through so that they can get to that place where there's no longer that mental block. And sometimes it stems from just maybe being married for years, or even a simple situation where one party really wants the divorce and the other doesn't. And you find that they may not say in plain words that I don't want this divorce, but it just manifests in different ways, and then being unresponsive to, you know, to disclosure requests, or just not negotiating in good faith and dragging things on. And it's not really about them necessarily being good or bad people. At the end, it's just them not wanting that divorce. Sometimes it's a conscious decision and sometimes it's unconscious. So working with that family therapist or counselor can help them realize, you know, give them insight into their behaviors and maybe help them deal with it and understand that, you know, the other party wants to separate, and there's, you know, you just have to deal with these issues now. So it benefits both parties, right? One party gets self-awareness and just goes and deals with the underlying issues around their separation, while the other party can also patiently acknowledge where the other person is, and eventually like actually gets the result that they want, which is the divorce, right? And you could do this without without that threat of court, and just ending things in a way that erodes all of the good parts of the relationship. And we acknowledge that even though you're where you are now, you're where you are, you're going through that separation, you're going through that divorce, and it's okay, but there might have been, you know, years of happiness at some point, right? And much as you're transitioning to different separate lives, we don't necessarily it doesn't make all of it bad, and we want to be able to still preserve whatever goodwill that there was at some point. So why would you go through the collaborative process? Well, if you just want peace of mind, if you just want to do things in a more cost-effective way. And if you notice, I am not using the word cheaper, though I do think it is less expensive for sure, but the funds, and I would touch on that in a minute, but it's also been done more cost effectively. If you want to be, if you want an agreement that involves yourself and that really listens to the voice of the children, then the collaborative process is the right one for you. And, you know, if you just want to maintain some sort of sanity for yourself and not have to deal with all the anxiety involved with other processes. Now, as I said, if you've there's other ways to do this, right? If you trust that you would negotiate a good deal for yourself, by all means, go ahead, just negotiate with your partner. The problem is, more often than not, without having that lawyer representation, you would be surprised how much more you're leaving on the table. And it's usually amusing to me when years after I get agreements and I look at it and I see parties, and it's usually the one party that's insisting that no lawyers be involved, and you see that the deal wasn't even good for them, right? So even while working within the ambit of the law, and I know that there's a lot you can read up and things like that, but there's a lot that you don't know because it's not your job, right? Like no matter how well I try to paint, I can do it as well or as efficiently as someone that's a professional, right? So if you also want to save costs by maybe involving a mediator, but a lot of times again, it's still you getting independent legal advice from two lawyers that chances are never really get to speak about your case, or even when they do, it's not, the process is not designed to brainstorm to make sure that your interests are met. So give me one quick second. I see a question here, so I'm just going to jump in. Can you go through a collaborative route if the other party is bent on making things difficult? The more difficult the other party, the better collaborative is for you. Now, the first step, obviously, is to get the other side to the other party to see that collaborative, to agree to go talk to a collaborative lawyer, right? Because not all lawyers are collaboratively trained. So there's training that needs to be done for you to be considered a collaborative lawyer. But besides that, if they go hire someone that's very aggressive and not settlement focused and not wanting to collaborate, because I think besides just using I don't want to use the word settlement, because with collaborative, it's really about collaboration. And it's really about, knowing that when two people come together trying to get to a result, that they may come up with better options than if each party did it on their own individually. This is not just something that happens in the collaborative process alone. It happens everywhere. That's why, even with, when people try to come up with product ideas and things like that, there's a reason why people come together as a team to brainstorm product ideas, right? And usually they come up with something better than just having people work alone individually. So that's really what the collaborative process tries to tap into. So what I would suggest, if you have a party that's being very difficult, is to just find any way to get them to go talk to a collaborative lawyer. And what we've done at our firm is we would maybe send that party, the other party. So we speak with you and we believe that you would benefit from the collaborative process, because obviously this is not for everyone. I think it should be, but as I said earlier, there's just some people that you need to go through litigation for. But if we find that your case would benefit from the collaborative process, then we could even send a quick email or draft something to you that you could give to your ex, just kind of suggesting that they go talk with a collaborative lawyer, and that we think it would be a process that would be suited for you, and let them understand that it's not about you getting less. You would actually get everything you want and possibly more, but you just get it in a better way. You get what you actually want, rather than fighting for what you think, just not fighting for your positions, but actually fighting for exactly what it is that you want, which more often than not is not as it's really not the polar opposite of what the other side wants. You would be surprised how when we take away things that, at the root of all of this is just the same desires that both sides want. So it's really just getting them to go talk to another collaborative lawyer. And usually when they do, then both sides, both lawyers can come together and try to make things work. And I think the more difficult the process, as I said, the better it is to be involved in the collaborative process. It would save you tons in legal fees, because if you go through the court process, it's the usual opposite sides and not really getting any results besides what, each party just really sticking to their sides and just getting a judge to make the decisions. Which, if it is what it has to be in your case, that's fine. But I really think that everyone should really think about trying the collaborative process, and if possible, having a collaborative team to work with. So I have a couple of questions here that I also really want to jump to before we're done. So someone asked, what's the difference between mediation and arbitration, and which is, sorry, mediation and collaborative family law, and which is better? Um, so I am a trained mediator and a trained collaborative professional. So I can say if they're both great processes. The difference with collaborative is just both parties have legal representation, which is not always the case in mediation. I would hesitate to say that one is better than the other, because at the end of the day, you're actually getting results. There's things I like about both. So they're both I love both because they're both alternatives to going to court. Um, with mediation, the difference is just you have one person that's trying to facilitate a settlement, as opposed to collaborative, where you have two lawyers. And I think the collaborative process is probably better suited for more difficult cases and than mediation. So if it's simple enough and you're in an amicable relationship with the other party, and you just need that third party facilitator, then I would say mediation is probably better for you. But if you think that there's, maybe we agree on some issues, but there's some issues where we're going to be stuck on and stuff like that, and, and you anticipate some difficulties ahead, then maybe the collaborative process is probably better for you. If there's going to be concerns with disclosure, most certainly go with the collaborative process. If you really see a lot of difficulties with coming up with a parenting schedule, then for sure go with the collaborative process. And if it's, if you're just not if you just don't have the most amicable relationship, then the mediation may not work for you. You may be better off with the collaborative process. Having said that, it doesn't mean that, if you're not in a good if you're not in an amicable relationship, that mediation wouldn't work for you. That's not what I'm saying. We're trained professionals. We know how to navigate around difficulties. But I find that if you have both parties as lawyers, both parties have lawyers, and both lawyers are able to negotiate for their parties' interests, I think that's a better process, especially when you throw in, that financial specialist that's able to deal with disclosure issues, and throw in that family coach that can even sometimes help the children, for example, work through the difficulty of a separation process, right? That's something that you would never get in mediation. So they're both fantastic processes, but depending on your situation, collaborative may be better, or just simply having a mediation. So that's what you do when you talk to a lawyer. Tell them, I'm thinking about, I don't want to go to court. I want to deal with things differently, and these are the challenges that I'm having in my situation. What process would you advise? So the other question is, what cases are best suited for the collaborative family law process? Okay, so I think I kind of touched on that earlier. Again, I think every case, if it's difficult, for sure, bring it to the collaborative process. That it's even the more difficult it is, the more you want to participate in collaborative family law, because then we're able to focus on the difficulty of the legal issues, and not just difficult characters, right? And the more difficult it is, maybe the more the team approach would be able to get us solutions, rather than going to a judge that's just going to give you a solution that, frankly, most times both parties even walk away not even appreciating, right? So I think every case is suited to collaborative family law if the other side commits to signing the participation agreement. Once they sign, they're part of it, right? And usually most parties are committed once they sign. Now, obviously, if the parties are, if one party is not responding to communications, you can't even get them to commit to seeing a collaborative family law lawyer or signing the participation agreement and things like that, then that's a clear sign that this case is probably not suited to collaborative family law. But in general, every case can be dealt with quicker, faster, more cost effectively by using a collaborative process. And the last question I have here says, collaborative sounds expensive. And that's a great question because, yes, I had said earlier that I wasn't using the word cheaper. I was using the word more cost effective. So collaborative sounds more expensive because you're working with a team and it looks like, oh my God, how are we going to pay for, this family professional, and there's the financial professionals and the lawyers. So step one is, the great thing is, if you the work gets done by people that a lot of the work gets done by people that charge way less than lawyers do. So the time it takes that lawyer to draft your parenting arrangements, and the time that it's taken a lawyer to follow up for disclosure and review the disclosure and things like that, all of that work now gets done by people that charge a fraction of what lawyers do, right? So it might look like it's a lot of people that's being paid, but it's more cost effective because they're at lower hourly rates. The other thing with the collaborative process is it's way, way cheaper than litigation. If you have to go to court, you would spend a lot more. The difference with the collaborative process is right out from the beginning, you've decided court is not an option. No one's threatening to go anywhere. We're going to buckle down and we're going to really look at what the issues are and we're going to deal with them. So no, it is not more expensive. It sounds that way, but it's not. Eventually you end up spending way less and you get your results way quicker with the collaborative process. And obviously, it's a more respectful way, more dignified way to do things. So I see a question. What if there's no children involved, but the other party has stated they don't want to sign, even though there's been a separation agreement for many years, therefore won't be willing to get a lawyer? That really is a tricky one, because if they're not willing to get a lawyer, then they're not likely to be involved in the collaborative process. Unfortunately, this might be one of those cases where you may actually have to go to court, right? But I mean, before that's obviously the easy and lazy way to do this, I would say, because if I if I took the time, or if you took the time and you could maybe just maybe get them to have one meeting with a collaborative lawyer, we may find out that maybe they're not signing the separation agreement because it's not reflecting what they want. Now, if you remember, I had talked earlier about, sometimes people just being difficult because they have just emotionally not accepted that the divorce is real, the separation is real, and that this relationship is over. So sometimes, instead of just dealing with that process and getting the support that they need through that process, they just, you find the party just making things difficult by not so, and in some cases maybe it's just not, maybe the separation agreement reflects everything they want, maybe they've even moved on, and it may just be, we may just be dealing with someone that just wants to make life difficult. And then in that case, if they're not willing to go talk to a collaborative family law lawyer so that we can maybe uncover what the true reasons are, what their real interests are beyond just a separation agreement and getting it signed, well, there's nothing you can do. They have to take that first step to commit to the process. And then within that process, we're able to deal with things holistically. My advice in that case would be maybe just go to court. And the fact that your matter is in litigation doesn't mean you can't go, you can go from litigation into the collaborative process, right? So if someone is not signing a separation agreement that, for many years, then maybe it's time to bring that court application. Because with court, they have 30 minutes, 30 minutes, that's funny. They have 30 days to respond to your application, right? And if they don't respond within 30 days, then one of two things can happen. You can either proceed uncontested, which means you get everything you've asked the courts for, which is just as good as your separation agreement. So ask for everything that's in your separation agreement. If they don't participate and the court grants an order, then you've gotten exactly what you wanted anyway, without having to wait for years for them to sign it. So that's one way they actually respond within they don't respond within the timelines and you get what you want. or they actually respond, right? And then now you can see what the issue is. It might be an issue with their agreement. It might just be that they, as I said, they just don't want to accept the fact that things are over. They just want to make your life difficult. Either way, now they're forced to be on the table. And when they're there, then maybe you can still talk to them about the better way of doing things. Like, why are we in litigation? We don't need, a judge to decide this. Maybe let's, I've heard about this collaborative process. Do you want to go talk to a lawyer? And if you Google, in most cities, there's different branches of collaborative, chapters of collaborative lawyers, and you can go on their websites, and maybe you can, look up some names and talk to a collaborative lawyer, so that we don't have to do this in litigation and get maybe results that is not satisfactory for either one of us anyways. And we can go through a process that, yes, we may not get 100% of what we want, but we would come out with results that are way more satisfactory than going to court. So you could, and then, so you could take things out of litigation, I'm saying, and now come into the collaborative process. Or if your case is one of the unfortunate ones that just has to follow that litigation process to the end, then, it will be what it is. But at the end of the day, you just have to end this, right? You can't wait forever. Okay, so that's it for questions. And that's all the information that I have to share with you today. Obviously, as you think things over, you may have other questions in the future. We have Q&As that we do at the firm here, and I will be happy to talk to you more about the collaborative process and if it's right for your own specific situation, because there's a reason why there's a range of different processes, right? While I think collaborative is a great way, it's the better way. I know it's not the only way. It's just one of the tools in our toolbox here at AP Lawyers in trying to resolve your family disputes. We would negotiate for you. We would mediate your matters. We're collaboratively trained. And we're also very aggressive litigators for those situations that call for that. But I do genuinely think that, going through the collaborative process would serve most people. And I really love the fact that we can come up with ideas, between two lawyers, that's way better than what parties can come up with individually, or each lawyer on their own can come up with. And I really do think it's the better way. And I would like to see more cases sort of go through the collaborative process if possible. So anyway, that's it for today. Thank you for tuning in. And, do join us next time. If you have any ideas for any topics you would like us to talk over during these webinars, feel free to send us an email. And I look forward to seeing you again in the future. Bye for now.